We are going to start off today discussing parents' rights and responsibilities in achieving education services. Before we begin, please complete the first two columns of the KWL sheet. K means what you know, W means what you want to know, and L is what you've learned. By the end of the workshop, we hope that you are able to complete the last column with everything that you've learned. If your W column has not been answered by the end of a section, please come up and let us know, and we'll be more than happy to answer those questions for you. Participants will have a greater understanding of what IDEA is, the Individuals with Disabilities Education Act, gain knowledge of what an individualized family service plan provides, understand the purpose and content of an effective IEP, increase their understanding of what Section 504 can and can't provide and the difference between of Section 504 and what an Individuals with Disabilities Act can do. Be able to identify what's important to have in your home files and what rights you have to access those records. Lastly, gain information on what FERPA is and what students it applies to. So, how did it all start? These were the three court cases that opened the door to education for individuals with disabilities. Brown versus Board of Education of Topeka. This was a landmark United States Supreme Court case in which the court declared state laws establishing separate public schools for black and white students to be unconstitutional. The second case, the Park case. Now, this uses language that we no longer use today for good reason, but for history's sake, we're going to use the language. Pennsylvania Association of Retarded Citizens, Park, versus the Commonwealth dealt with the exclusion of children with mental disabilities from public schools. They took action against the State Education Board and 13 specific school districts within the state of Pennsylvania. The court ruled that exclusion of children with mental disabilities from a public school education was indeed a denial of equal protection clauses and of their state-given property right. The federal courts ordered that the state policies and practices be altered to allow those children with mental disabilities access to the public education system. Additionally, the court ruled that a parent has a right to due process if their child is being denied the right to a public education. Pennsylvania became the first state to guarantee every children with mental disabilities the right to a free public education. And lastly, Mills versus Board of Education of the District of Columbia. This case ruled on behalf of 7 children with behavioral, emotional, and learning impairments fighting for access to a free and suitable education regardless of any impairment or disability. The ruling required the schools prepare an education proposal for each child with a disability being served by a school. This is our present-day Individual Education Program, or IEP. So, the Civil Rights Act of 1964 was signed into law by President Johnson. Title II outlawed discrimination based on race, color, religion, or national origin in hotels, motels, restaurants, theaters, and all other public accommodations engaged in interstate commerce. Can someone give me an example of this? Examples of answers include separate seating areas in restaurants, separate bathrooms, and drinking fountains. Title III prohibited state and municipal governments from denying access to public facilities on grounds of race, color, religion, or national origin. Can anyone give me an example of this? The Montgomery bus boycott when Rosa Parks refused to move to the back of the bus is one example. And the Mississippi Freedom Democratic Party when 83 delegates were denied access to the Democratic National Convention in Atlantic City due to the color of their skin. Title IV encouraged the desegregation of public schools and authorized the U.S. Attorney General to file suits to enforce the said act. Can someone give me an example of this? Well, first one, Brown versus the Topeka Board of Education when students were being educated in segregated schools under the premise that separate but equal was appropriate. The second one is integration of Little Rock, Arkansas Central High School, where the Little Rock Nine were intimidated by students, the mayor, the governor, and the Arkansas National Guard. Ultimately, they overcame. Title VI prevents the discrimination of government agencies that receive federal funds. If any agency is found in violation of Title VI, that agency may lose its federal funding. This allows the federal government to assure the act is being followed by providing a way to punish those who do not abide by the law. Several of the titles within the act directly affected future rulings, offering further protecting of our children who have disabilities. We have a poll question here. When considering the potential rights of a student, who determines what laws apply? 1 being the parent, raise your hand. The school? The State Department of Education? Or is it determined by how the child qualifies? For those of you who chose the last one, you are correct.